This is wild HOA situations. Let me set the scene fast. I am escalating this today, do you understand? That is what Vanessa Smith shouted across the mailbox cluster while waving a plastic evidence sleeve like it was a court summons. She stood there in her pink blazer and pink visor, pointing at the violation list taped inside the mail kiosk, my name circled in red marker. She told me she was proud of putting it back on the list. I work as a regional field technician, always on a deadline, always juggling contract jobs across 3 states. Missing even one day could end a contract. Vanessa knew that. She smiled when she said it. This was not the first time my name had appeared on that list. 6 months ago, the same violation showed up. I proved it was wrong, and it disappeared. Now, it was back. Vanessa stood between me and the mailbox, arms crossed, that laminated policy sheet in one hand. She told me the board had reviewed my case and determined that the original violation was never resolved. I asked her what case. She said the parking enforcement action from last fall. I told her I had documentation proving I was out of state that entire week. She smiled again and said, "Keep talking, I love adding notes." The landing at Harborview Community Association sits on the edge of St. Paul, Minnesota, where normal life becomes an enforcement opportunity. Every driveway is monitored. Every guest vehicle is logged. Every trash bin placement is photographed. Vanessa runs the communications office, which means she controls every email blast, every newsletter, every violation notice that goes out to the neighborhood. If you want to dispute a fine, you email her. If you want records, you request them through her. If you want to attend a meeting, she sends you the link. She is the gatekeeper, and she knows it. I asked her for a copy of the violation notice. She told me it was in the system and I could request it through the portal. I pulled out my phone and opened the portal right there. My account showed 0 active violations. I turned the screen toward her. She glanced at it and said the system was updating and I should check back in 24 hours. I asked her how my name could be on the public list if it was not in the system. She said that was a question for management and walked away. That night I sat at my kitchen table with every piece of paperwork I had saved from the last 6 months. Receipts, emails, work orders, travel confirmations. I document everything. Receipts mode is not just a style. It is survival when you are dealing with people who rewrite history. The original violation claimed I had parked a work vehicle in a guest spot overnight for 3 consecutive nights in October. I was in Fargo that entire week installing fiber backbone for a hospital. I had hotel receipts, GPS logs from my truck, and a signed completion report with timestamps. I submitted all of it through the portal in November, and the violation disappeared. Now it was back, and Vanessa was telling me the board had determined it was never resolved. That did not make sense. I logged into the portal again and pulled up my submission history. The October upload was gone. Completely wiped. I checked my email for the confirmation. It was still there. Upload successful, case number assigned, estimated review time 3 business days. I screenshotted everything and saved it to 3 different places. The next morning I called the management company. The woman who answered told me she would need to transfer me to the compliance department. I waited on hold for 11 minutes. When someone finally picked up, I explained the situation. She asked for my address and case number. I gave her both. She put me on hold again. When she came back, she told me there was no record of my submission. I told her I had the confirmation email. She said the portal had been migrated to a new system in December and some records did not transfer. I asked her if that meant my evidence was gone. She said I would need to resubmit. I asked her what the deadline was. She said the board packet was being finalized that afternoon, and I had to get my evidence included before it was sealed. That gave me 4 hours. I told her I would upload everything immediately. She gave me the new portal link and hung up. I opened the link and logged in. The interface was different, but the case number field was the same. I uploaded every file I had: hotel receipts, GPS logs, work orders, travel confirmations, signed reports, photos with timestamps. I hit submit and waited for the confirmation page. The page refreshed. Upload failed. No error message, just a blank screen. I tried again. Same result. I cleared my cache and restarted my browser. Same result. I checked the time. 3 hours left. I called the management company again and got a different person. I explained the upload issue. She told me the portal was working fine on her end and I should try a different browser. I tried 3 different browsers. None of them worked. She suggested I email the files directly. I asked for the email address. She gave me a generic submissions inbox and told me to include my case number in the subject line. I sent the email with every file attached. 2 minutes later, I got a bounce back. Attachment size exceeded. I compressed the files and resent. Another bounce back. I called again. This time, the woman told me I would need to submit a physical packet at the management office. I asked where that was. She gave me an address in Roseville, 23 minutes away. I checked the time. 2 hours and 40 minutes left. I printed everything, stuffed it into a folder, and ran to my truck. The management office was in a low brick building behind a strip mall. I parked and ran inside. The lobby was empty except for a woman at the front desk. I told her I needed to submit documents for the board packet. She asked if I had an appointment. I told her no, but I had called ahead and was told I could drop off a physical packet. She looked at her computer and said there was no note about that. I asked her if she could accept the packet anyway. She said she would need to check with her supervisor. She picked up her desk phone and dialed. I stood there holding my folder, watching the clock on the wall. She spoke quietly into the phone, nodded, and hung up. She told me her supervisor was in a meeting and I would need to wait. I asked how long. She said she did not know. I asked if I could just leave the packet with her. She said she was not authorized to accept board submissions. I asked who was. She pointed to a closed door at the end of the hallway and said the compliance manager would be back in 15 minutes. I sat in the lobby and waited. 15 minutes passed. Then 20. Then 30. I walked back to the desk and asked if the compliance manager was available yet. The receptionist called again. This time she told me the manager had left for lunch and would be back in an hour. I asked if there was anyone else who could accept the packet. She said no. I asked if I could slide it under the door. She said that would not be considered an official submission. I checked my phone. 1 hour and 10 minutes left. I drove back home, scanned every document into PDFs, and uploaded them to a cloud folder. I sent the link to the submissions inbox with my case number and a note explaining the portal issue. Then I sent the same link to every board member email I could find on the HOA website. Then I sent it to Vanessa directly. Her auto reply said she was out of the office and would respond within 2 business days. At 3:30, I got an email from the management company. Subject line: board packet finalized. The body of the email thanked all residents for their submissions and confirmed that the packet had been sealed. Any materials received after the deadline would be held for the next meeting in 6 weeks. I replied immediately and asked if my submission had been included. No response. That evening, I got a notice in my mailbox. It was printed on HOA letterhead and dated that same day. It informed me that the board had reviewed my October parking violation and determined that I had failed to provide adequate documentation. The fine was being reinstated at $250, plus a $50 late fee, plus a $75 administrative processing fee. Total, $375. Due in 14 days. Failure to pay would result in additional penalties, including potential lien action and loss of amenities access. I read the notice 3 times. Then I read it again. Adequate documentation. I had submitted hotel receipts, GPS logs, work orders, signed reports, and photos with timestamps. What part of that was inadequate? I called the management company again. The automated system told me the office was closed and I should call back during business hours. I sent an email to the compliance manager, the board president, and Vanessa. I explained that I had submitted everything before the deadline, that the portal had failed, and that I had proof of the upload confirmation. I asked for a review. The next morning, Vanessa replied. She thanked me for reaching out and explained that the board had carefully reviewed all available materials. Unfortunately, my submission had not been received by the deadline, and the policy was clear that late submissions could not be considered for the current enforcement cycle. She said I was welcome to resubmit for the next meeting, but the fine would remain in effect until the matter was resolved. She signed off with a smiley face emoji. I forwarded her email to the board president and asked for clarification. If the portal had failed and the management office had refused my physical packet, how was I supposed to meet the deadline? No response. I forwarded the email again with a read receipt request. The receipt came back within 2 minutes. The president had opened it. Still no response. That afternoon, I went back to the mailbox cluster to check for any new notices. Vanessa was there again, this time with another resident. She was explaining something about guest parking rules and pointing to a diagram on her clipboard. The other resident looked exhausted. When Vanessa finished, she turned to me and smiled. She asked if I had received the board decision. I told her I had. She asked if I planned to pay the fine. I told her I was disputing it. She said, "Keep talking, I love adding notes." I asked her why my submission had not been included in the packet. She said the deadline had passed before my materials arrived. I told her I had the upload confirmation timestamp. She said the confirmation did not mean the files had been successfully received. I told her I had sent the cloud link directly to her and the board. She said cloud links were not accepted as official submissions. I asked her where that policy was written. She tapped the laminated policy sheet in her hand and said it was in the updated enforcement guidelines, which had been emailed to all residents in January. I pulled out my phone and searched my email for anything from the HOA in January. Nothing. I asked her what date the email had been sent. She said, January 4th. I showed her my inbox. No email on January 4th. No email from the HOA at all since December. She shrugged and said that was a deliverability issue and not her problem. I asked her for a copy of the updated guidelines. She said they were posted on the portal. I opened the portal on my phone and navigated to the documents section. The most recent enforcement guidelines were dated October of last year. She told me the portal was behind and the updated version would be available soon. I asked her how I was supposed to follow rules that I could not access. She said ignorance of the rules was not an excuse. I asked her who had approved the January guidelines. She said the board had. I asked her when the vote happened. She said that was internal board business. I told her board votes were supposed to be public record. She said not all votes were subject to public disclosure, especially procedural updates. That night I started digging. I went back through every email I had received from the HOA for the past year. I found the original violation notice from October. I found the confirmation that it had been resolved. I found the November email stating my case was closed. Then I found something strange. In December, I had received an email about holiday decorations guidelines. The sender was Vanessa, but the signature block listed her title as Communications Director and Interim Compliance Officer. Interim. I had never heard that before. I searched for compliance officer in my email history. The previous compliance officer was a man named Greg. He had sent the October violation notice. He had also sent the November resolution email. Then, nothing. I searched the HOA website for Greg. His name was gone from the staff directory. Vanessa was listed as the sole contact for all compliance and communications matters. I called the management company the next morning and asked to speak to Greg. The receptionist told me Greg no longer worked there. I asked when he had left. She said she could not share personnel information. I asked who had taken over his duties. She said compliance matters were now handled by the board-appointed liaison. I asked who that was. She said Vanessa Smith. I asked if that appointment had been announced to residents. She said she did not have that information. I went back to the HOA website and pulled up the meeting minutes. The most recent minutes posted were from October. Nothing from November, December, or January. I emailed the board president and asked when the November and December minutes would be posted. No response. I emailed Vanessa and asked the same question. She replied within an hour and said the minutes were being finalized and would be posted once approved by the board. I asked when that would be. She said she did not have a timeline. I decided to call the city clerk. I had heard that HOA records were sometimes kept on file with the city for public access. The clerk who answered was friendly and asked what I needed. I explained that I was trying to get copies of board meeting minutes that had not been posted online. She asked for the name of the HOA. I told her the Landing at Harborview Community Association. She put me on hold and came back 2 minutes later. She said they did have some records on file, but they were not complete. I asked what that meant. She said the HOA had submitted minutes for October, but nothing after that. I asked if that was normal. She said it depended on the HOA, but most submitted monthly. I asked if I could request a copy of the October minutes. She said they were public record and I could pick them up in person or request a PDF by email. I asked for the PDF. She said she would send it within 24 hours. I thanked her and hung up. Then I called back and asked if there was a way to request records directly from the HOA. She said yes. Under Minnesota law, I could submit a written records request to the board, and they were required to respond within 10 business days. I asked if there was a form. She said I could write a simple letter stating what I wanted and send it certified mail. That evening, I drafted a records request. I asked for copies of all board meeting minutes from November through January, all enforcement guidelines updates, and all documentation related to my October parking violation case, including the original submission I had uploaded in November. I printed the letter, drove to the post office, and sent it certified mail to the HOA address listed on the website. 3 days later, I got the October meeting minutes from the city clerk. I opened the PDF and started reading. The minutes were 4 pages long and covered standard business, budget reports, landscaping updates, holiday lights rules. On page 3, there was a section titled Compliance Officer Transition. It stated that Greg had resigned effective October 30th, and the board had voted to appoint Vanessa Smith as interim compliance officer until a permanent replacement could be hired. The vote was listed as 4-1 in favor. I read the section twice. There was no mention of why Greg had resigned. There was no timeline for hiring a replacement. There was no discussion of what interim responsibilities Vanessa would have. Just a vote and a title. I kept reading. On page 4, there was a section titled Enforcement System Migration. It stated that the compliance portal would be migrated to a new platform in December, and residents would be notified via email once the transition was complete. The vote was listed as unanimous. I went back to my email and searched for any notification about the portal migration. Nothing in December. Nothing in January. Nothing at all. I checked my spam folder. Still nothing. I opened the portal again and looked at the URL. It was the same URL I had been using since I moved in. If the system had been migrated, why was the URL the same? I clicked on the About section at the bottom of the page. It listed the platform version and last update date. Last update, September. That did not make sense. The October minutes said the migration would happen in December. The management company had told me the portal had been migrated and some records did not transfer. But the portal itself showed no update since September. I took screenshots of everything and saved them to my evidence folder. The next day, I got a response to my records request. It came from Vanessa. She thanked me for my inquiry and explained that the board had reviewed my request. Unfortunately, the minutes I had requested were still in draft form and had not been approved for release. She said they would be posted on the website once finalized. As for my October case documentation, she said the file had been archived as part of the system migration and retrieval would require a processing fee of $50 per incident. She said I could submit payment through the portal and the documents would be provided within 30 business days. I replied immediately. I told her that Minnesota law required HOAs to provide records within 10 business days of a written request, and that charging a retrieval fee for my own case file was not standard practice. I asked her to provide the documents without the fee. She replied 2 hours later. She said the 10-day requirement applied to approved minutes and financial records, not draft minutes or archived case files. She said the fee was necessary to cover administrative costs. She said if I disagreed, I was welcome to consult an attorney. I did not have time to consult an attorney. I had a contract deadline in 2 days and I was already behind schedule because of this mess. I decided to pay the fee and move on. I logged into the portal and navigated to the payment section. The fee was listed under Document Retrieval Services. I entered my case number and submitted payment. The confirmation page said my request had been received and I would be contacted within 30 business days. 30 business days. That was 6 weeks. The fine was due in 11 days. If I did not pay, the HOA could place a lien on my property or suspend my amenities access. I called the management company again and asked if there was a way to expedite the retrieval. The woman who answered said no. I asked if I could appeal the fine while waiting for the documents. She said appeals had to be submitted in writing to the board and would be reviewed at the next meeting. The next meeting was in 4 weeks. I asked what I was supposed to do in the meantime. She said I could pay the fine and request a refund if the appeal was successful. I hung up and stared at the notice on my table. $375 for a violation I did not commit, based on evidence I had already submitted, in a system that had deleted my proof and charged me to get it back. I felt the anger rising, but I kept it down. Rage does not win these fights. Proof does. I opened my laptop and started building a timeline. Every email, every phone call, every notice, every bounce back, every screenshot. I put it all in a spreadsheet with dates, times, and source links. Then I went back to the October minutes. I read the compliance officer transition section again. Greg had resigned effective October 30th. My violation notice had been sent on October 15th, 2 weeks before he resigned. My resolution confirmation had been sent on November 8th, 9 days after he resigned. That confirmation had been sent from Greg's email address. But if Greg had resigned on October 30th, why was he still sending emails in November? I checked the email headers. The November 8th email had been sent from the HOA domain, but the sending server was different from the October email. I pulled up both headers side by side and compared them. The October email had been sent from the management company's mail server. The November email had been sent from a generic cloud email service. Someone had sent that email from a different system, using Greg's name. I went back to my email and searched for every message I had received from Greg. The last legitimate one was dated October 28th, 2 days before his resignation. It was a routine reminder about trash bin placement. After that, there was only the November 8th resolution email. I clicked on the sender address and checked the full details. The display name was Greg, but the actual email address was a generic forwarding address, norapply@oa-landingharborview.com. It was not Greg's personal work email. Someone had sent me a fake resolution email. Someone had made me think my case was closed when it was not. Someone had waited 6 months and then reopened it, knowing I would not have the original evidence anymore, and that someone had access to the HOA email system, the compliance records, and the board communications. Vanessa. I did not raise my voice because my proof was louder than any argument. I took screenshots of the email headers, saved them to my evidence folder, and added them to my timeline. Then I went back to the city clerk's office website and looked up the records request rules. Minnesota Statute 515BB.163 required HOAs to provide access to records within 10 business days. The statute specifically included board meeting minutes, financial records, and contracts. It did not say anything about draft minutes or retrieval fees for a resident's own case file. I called the city clerk again. A different person answered. I explained the situation. I had submitted a records request. The HOA had refused to provide the minutes because they were still in draft form, and they were charging me $50 to retrieve my own case file. I asked if that was legal. She put me on hold and came back 3 minutes later. She said draft minutes were still considered board records and should be provided within 10 business days, even if they had not been formally approved. She said charging a retrieval fee for a resident's case file was unusual, and I should ask for a written explanation of the fee policy. I thanked her and hung up. Then I sent another email to Vanessa. I told her that I had consulted with the city clerk and that draft minutes were required to be provided under Minnesota law. I asked her to send the November, December, and January minutes immediately. I also asked for a written copy of the document retrieval fee policy. I sent the email certified read receipt. The receipt came back within an hour. Vanessa had opened the email. No response. 2 days later, I got a new notice in my mailbox. This one was different. It was printed on bright yellow paper and had a red border. The heading said Amenities Lockout Notice. The body of the notice informed me that due to my outstanding balance and failure to respond to previous communications, my access to community amenities would be suspended effective immediately. This included the fitness center, the pool, the clubhouse, and the guest parking permits. The suspension would remain in effect until all outstanding balances were paid in full. I did not use the amenities. I barely had time to sleep, let alone work out or swim. But the guest parking permits were a problem. I had family visiting in 3 days, and without a permit, their car would be towed. I called the management company and asked how to get a temporary permit. The woman who answered said amenities access was controlled by the board and I would need to resolve my balance first. I told her I was disputing the balance. She said disputes did not pause enforcement actions. I asked if I could pay under protest. She said I could note my protest in the memo line of the check, but payment was required to restore access. I hung up and checked my bank account. I had the money, but paying meant admitting I owed it. It meant letting Vanessa win. It meant funding a system that was stealing from me. But if I did not pay, my family would get towed, and I would end up paying even more in tow fees. I wrote the check, wrote paid under protest in the memo line, and drove to the management office. The same receptionist was at the desk. I handed her the check and asked for a receipt. She printed one and handed it to me. I asked when my amenities access would be restored. She said it could take up to 3 business days to process. I asked if I could get a temporary guest permit in the meantime. She said I would need to wait for the access restoration. I told her my family was arriving in 3 days. She said she understood, but there was nothing she could do. I drove home and sent an email to the board president. I explained that I had paid the fine under protest, that I was still disputing the violation, and that I needed a guest parking permit for this weekend. I attached a copy of the payment receipt. No response. I sent the same email to Vanessa. She replied within 20 minutes. She said guest parking permits were issued through the amenities portal, and I would regain access once my payment had been processed. She said processing could take 3 to 5 business days depending on volume. 3 to 5 business days. My family was arriving in 2 days. I replied and asked if there was any way to expedite the processing. She said no. I asked if I could request a permit manually. She said manual requests were not accepted. I asked what I was supposed to do. She said I should have paid the fine sooner. She ended the email with "Keep talking. I love adding notes." That was the second time she had used that line. The first time was at the mailbox cluster. Both times she had said it with the same smug smile, the same certainty that she was untouchable. I can fine you daily until you give up and you cry. That was what she had told another resident at the mailbox cluster a few weeks ago. I had heard it myself. She had said it loudly enough that the rideshare driver waiting nearby had rolled his eyes and shaken his head. I went back to my evidence folder and pulled up the timeline. I added the amenities lockout, the payment under protest, and the permit denial. Then I opened a new document and started writing down every strange thing that had happened since October. Greg's resignation, the fake resolution email, the missing November and December minutes, the portal that had not been migrated, the upload failures, the refused physical submission, the retrieval fee, the amenities lockout, the permit denial. Every single one of those events had been controlled or influenced by Vanessa. She had taken over Greg's job. She controlled the email system. She controlled the portal. She controlled access to records. She controlled amenities. She was the gatekeeper, and she was using that power to punish anyone who questioned her. But why? What did she gain from targeting me? I was nobody. I paid my dues on time. I did not go to meetings. I did not complain about landscaping or trash bins. I was invisible. Or at least I had been, until I challenged the October violation. That was when everything had changed. That was when Vanessa had started moving the goalposts, denying my evidence and charging me fees. I went back to the October minutes and read the enforcement section again. There was a note about increasing compliance rates through stricter documentation requirements and faster processing of repeat offenders. Repeat offenders. That phrase stood out. I searched my email for any previous violations. Nothing. I had lived here for 2 years and never received a single notice until October. So why was I being treated like a repeat offender? I called the management company and asked to speak to someone in compliance. I got transferred to a voicemail. I left a message asking for my full compliance history, including any warnings or violations from the past 2 years. I said I was willing to pay any necessary fees for the records. No one called back. That night I could not sleep. I kept thinking about the timeline, the fake email, the missing minutes, the portal failures. It was too coordinated to be random. Someone had planned this. Someone had targeted me specifically. But I still did not know why. The next morning, I got an email from the board secretary. It was not addressed to me personally. It was a forwarded message with a long chain of replies. The subject line said January Board Packet Nomic Final Draft. I opened it and started reading. It was the internal draft of the January meeting minutes, complete with notes and edits that had not been cleaned up for public release. I scrolled through the document. Most of it was standard, budget approvals, landscaping bids, pool maintenance schedules. Then I got to page 5. There was a section titled Compliance Enforcement Review. It listed every violation issued in the past 6 months, the resident name, the fine amount, and the resolution status. My name was on the list twice. Once in October with a resolution status of pending appeal. Once in December with a resolution status of reopened non-compliancy. December. I had never received a December notice. I had never been told my case was reopened. I kept reading. Below the list there was a note. Communications Director recommends escalating enforcement on repeat non-compliance cases to demonstrate board commitment to standards. Recommend issuing amenities lockout and formal lien notice if payment not received by January 31st. January 31st. That was yesterday. I had paid the fine 2 days ago, on January 29th before the deadline. But the email was dated January 15th, 2 weeks before the deadline, which meant Vanessa had already planned the escalation before I had a chance to respond. She had decided to lock me out and threaten a lien, regardless of whether I paid. I kept scrolling. On page 7, there was a section titled Personnel Update. It stated that the board had decided not to post the compliance officer position and instead make Vanessa's interim role permanent. The vote was listed as 3-2 in favor. One board member had noted concerns about consolidating too much authority in one role, but the majority had agreed that cost savings justified the decision. Vanessa now had permanent control over all compliance and communications. She could issue violations, deny appeals, control access to records, and communicate with residents without any oversight. The board had handed her the keys to the entire enforcement system, and she was using it to target anyone who challenged her. I forwarded the email to myself and saved it to my evidence folder. Then I sent a reply to the board secretary, thanking her for sending the draft and asking when the approved version would be posted. 2 minutes later, I got an automated bounce back. The email address had been deactivated. I tried calling the secretary's number listed on the HOA website. It went straight to voicemail. I left a message and hung up. Then I got a text message from an unknown number. You were not supposed to receive that email. Delete it immediately or face legal action for unauthorized access to internal board communications. No signature. No name. Just a threat. I took a screenshot of the text and saved it. Then I replied, I received the email because your secretary forwarded it to me. If it was sent in error, that is not my fault. I will not delete evidence of HOA misconduct. The message showed as delivered but not read. My family arrived that evening. I met them at the mailbox cluster and handed them a guest parking permit I had printed myself using an old template I found in my email archives. It was not official, but it had the HOA logo and looked legitimate enough. I told them to park in the guest lot and call me immediately if anyone said anything. They asked what was going on. I told them I was in the middle of an HOA dispute and it was complicated. They nodded and did not push. The next morning I woke up to a pounding on my door. I opened it to find a tow truck backed up to my driveway. The driver was hooking chains to my family's car. I ran outside and asked what he was doing. He said he had a work order to tow an unauthorized vehicle from the guest lot. I told him the car had a valid permit. He pointed to the windshield. The permit I had printed was gone. In its place was a bright orange violation sticker that said Unauthorized Vehicle Cow Tow in Progress. I asked the driver who called the tow. He pointed across the lot. Vanessa stood by her car, arms crossed, that laminated policy sheet in one hand. She walked over and handed the driver a clipboard with a work order. I asked to see it. The driver hesitated, then handed it to me. It was a standard tow authorization form with the HOA name at the top. The reason listed was, "No valid guest permit displayed." The authorization signature was Vanessa's. I pulled out my phone and opened my photos. I showed the driver the picture I had taken of the car with the permit clearly visible in the windshield. I told him the permit had been removed without my knowledge and replaced with a violation sticker. The driver looked at the photo, then at Vanessa, then back at me. He said he was just doing his job and I would need to take it up with whoever called the tow. I told him I was taking it up right now. Vanessa stepped forward and said the permit was not valid because it had not been issued through the official portal. She said any permits issued outside the system were considered fraudulent and subject to immediate tow. I told her I had paid my fine and requested a permit through the portal, but the system had not restored my access. She said that was not her problem. I asked her who had removed the permit from the windshield. She smiled and said she had, as part of her enforcement duties. If you are enjoying this story, hit that like button and subscribe for more HOA drama. I told the driver I was calling the police. Vanessa laughed and said the police would not respond to a civil HOA matter. I pulled up the non-emergency number and dialed anyway. The dispatcher answered and I explained the situation. Someone had removed a valid parking permit from my family's car and called a tow truck without my authorization. The dispatcher asked if the car was on private property. I said yes, HOA property. She said that was a civil matter and I would need to contact the property management company. I asked if removing someone's permit without permission was considered tampering. She said it could be, but I would need to file a report in person. I told the tow driver I was filing a police report and he should not proceed until it was resolved. He looked at Vanessa, then at me, then at his phone. He said he would call his dispatch and confirm. He stepped away and made the call. I could not hear the full conversation, but I heard him say something about a dispute and a police report. When he came back, he said his dispatcher had told him to wait until the issue was resolved. Vanessa was furious. She demanded to know why the driver was not proceeding. He said his company policy was to avoid towing disputed vehicles. She said there was no dispute, the vehicle was unauthorized, and she had signed the work order herself. The driver said he understood, but he was not moving the vehicle until the police confirmed it was okay. Vanessa pulled out her phone and called someone. She spoke loudly and quickly, pacing back and forth. When she hung up, she told the driver that the HOA attorney had confirmed the tow was legal and he needed to proceed immediately. The driver looked uncomfortable. He asked Vanessa for the attorney's contact information. She refused and said he needed to trust her authority. He said he was not towing anything without talking to his dispatcher first. He called again and explained the situation. This time he put the call on speaker. The dispatcher asked Vanessa to confirm her authorization. Vanessa said she was the HOA communications director and compliance officer and she had full authority to issue tows. The dispatcher asked if the vehicle owner had been notified. Vanessa said no, because the vehicle was unauthorized. The dispatcher said they could not proceed without notifying the owner first. Vanessa said the owner was standing right here and had been notified. The dispatcher asked if the owner had refused to move the vehicle. Vanessa said yes. I interrupted and said I had not refused anything. I said I was willing to move the car immediately if Vanessa would return the permit she had taken. Vanessa said there was no legitimate permit to return. I held up my phone and showed the driver and the dispatcher the photo of the permit in the windshield. I explained that Vanessa had removed it and replaced it with a violation sticker. The dispatcher asked Vanessa if that was true. Vanessa said she had removed a fraudulent permit as part of her enforcement duties. The dispatcher said that sounded like a civil dispute, and the tow company was not going to get involved. She told the driver to release the vehicle. The driver unhooked the chains and got back in his truck. Vanessa started yelling at him, saying he was violating his contract with the HOA and she would report him to his company. He ignored her, started the engine, and drove away. Vanessa turned to me and said this was not over. She said I had interfered with official HOA business and she would be filing a formal complaint with the board. She said I could expect another fine, possibly a lien, and definitely a suspension of all privileges. I told her to do whatever she wanted, but she was not touching my family's car. She said, "Keep talking, I love adding notes," and walked away. I went back inside and told my family what had happened. They were shaken. My sister asked if we should just leave. I told her no. This was my home and I was not going to be bullied out of it. I said I was going to fight this the right way, with evidence and legal pressure, and I was going to win. She asked how I could be so sure. I told her I had proof of everything, and Vanessa had just made a huge mistake. That afternoon, I went to the police station and filed a report for tampering and harassment. The officer who took the report was skeptical at first, but when I showed him the photo of the permit and explained that Vanessa had removed it without my authorization, he agreed to document it. He said it was unlikely anything would come of it, but the report would be on file if I needed it for a civil case. I asked for a copy of the report. He printed one and handed it to me. I added it to my evidence folder. Then I went to the management company office. I asked to speak to the regional manager. The receptionist said he was not available. I said I would wait. She said he was out of the office for the week. I asked for his email and phone number. She said she could not give out that information. I asked who I could speak to about Vanessa's behavior. She said all complaints about HOA staff needed to be submitted in writing to the board. I told her I had already tried that and the board was not responding. She said that was not something she could help with. I left the office and sat in my truck. I felt the anger building again, but I forced it down. Rage does not win. Proof wins. I pulled out my laptop and opened my evidence folder. I had everything. The fake resolution email, the missing minutes, the forged board packet, the portal failures, the retrieval fees, the amenities lockout, the permit theft, the tow attempt, the police report. I had it all documented with timestamps, screenshots, and receipts. But I needed more. I needed something that would force the board to act. Something that would prove Vanessa had been abusing her authority systematically, not just against me. I needed a pattern. I needed other victims. I opened the neighborhood group chat and posted a message. Has anyone else had issues with compliance violations that did not make sense or appeals that were denied without explanation? I am gathering information for a formal complaint and would appreciate any details you can share. I posted it and waited. Within an hour, I had 12 responses. One resident said she had been fined for a mailbox that was the wrong color, even though it was the same color as every other mailbox on the street. Another said he had been charged a late fee for paying his dues on time because the payment portal had been down, and the check had not been processed fast enough. A third said she had requested records 3 times and never received a response. A fourth said his amenities access had been suspended without notice, and it took him 3 weeks to get it restored. Every single one of them mentioned Vanessa. She had issued the fines. She had denied the appeals. She had ignored the records requests. She had suspended the access. She was the common thread. I sent private messages to each person who had responded and asked if they would be willing to provide written statements. 10 of them said yes. 2 said they did not want to get involved. I sent a template to the 10 who agreed, asking them to describe what happened, when it happened, and how Vanessa had responded. I told them they did not need to provide proof, just their account. Within 24 hours, I had all 10 statements. I compiled them into a single document and attached it to a formal complaint letter addressed to the board president. I explained that Vanessa had engaged in a pattern of abusive enforcement, selective rule application, and retaliatory behavior. I listed every incident I had documented, every statement I had collected, and every policy violation she had committed. I demanded that she be removed from her position immediately and that an independent audit be conducted of all compliance actions she had taken in the past 6 months. I sent the letter certified mail to the board president, the management company, and the HOA attorney listed on the website. 3 days later, I got a response. It was not from the board president. It was from Vanessa. She said the board had reviewed my complaint and determined it was without merit. She said my allegations were defamatory and I could face legal action if I continued to spread false information. She said the board stood behind her fully and any further complaints would be considered harassment. She ended the email with a reminder that my fine was still outstanding and I had 14 days to pay or face lien action. I read the email 3 times. My fine was still outstanding. But I had paid it. I had the receipt. I called the management company and asked them to confirm my payment. The woman who answered pulled up my account and said there was no record of payment. I told her I had paid in person and received a receipt. She said she would need to see the receipt to process a correction. I told her I would email it immediately. She gave me the email address and hung up. I scanned the receipt and sent it. Then I called back and asked if she had received it. She said yes, and she was forwarding it to accounting. I asked how long it would take to correct my account. She said up to 5 business days. I asked if the lien action would be paused while the correction was being processed. She said she could not make that determination, and I would need to contact Vanessa. I did not contact Vanessa. I waited. 5 business days passed. No correction. I called the management company again. This time, the woman said she had no record of my receipt email. I asked her to check her spam folder. She said she did not have access to that. I asked her who did. She said the IT department. I asked for their contact information. She said they did not take direct calls from residents. I sent the receipt again to 3 different email addresses: the general submissions inbox, the accounting department, and Vanessa directly. I got bounce backs from the first 2. Vanessa did not respond. I called the management company and asked to speak to a supervisor. I was put on hold for 18 minutes. When someone finally picked up, I explained the entire situation. She said she would escalate the issue and someone would contact me within 48 hours. No one called. 2 days later, I got a notice in my mailbox. It was a lien notice. The heading said Formal Lien Filing Notice. The body of the notice stated that due to my continued non-payment and failure to respond to previous communications, the HOA was filing a lien against my property in the amount of $375, plus $250 in legal fees, plus $100 in late fees, plus a $75 enforcement surcharge. Total, $800. The notice said I had 10 days to pay the full amount or the lien would be recorded with the county. I had paid. I had the receipt. I had sent it to the management company multiple times. And now Vanessa was threatening to file a lien anyway. This was not a mistake. This was deliberate. She was trying to force me out, and she was using the legal system to do it. I called the HOA attorney listed on the lien notice. I got a receptionist who asked what I was calling about. I explained that I had received a lien notice for a fine I had already paid. She asked for my name and address. I gave her both. She put me on hold and came back 2 minutes later. She said the attorney was not available, but she could take a message. I asked her to tell the attorney that I had proof of payment and the lien was fraudulent. She said she would pass along the message. I asked when I could expect a response. She said within 3 to 5 business days. I could not wait 3 to 5 business days. The lien would be filed in 10 days. If it went on record, it would destroy my credit and make it nearly impossible to refinance or sell my property. I needed to stop it now. I went back to my evidence folder and pulled up everything I had. The timeline, the fake resolution email, the missing minutes, the forged board packet, the portal failures, the retrieval fees, the amenities lockout, the permit theft, the tow attempt, the police report, the resident statements, the payment receipt, the lien notice. And then I saw it. The January board packet that the secretary had accidentally forwarded to me. The one that showed Vanessa had planned the escalation before I had a chance to respond. The one that proved she was targeting me deliberately. The one that she had texted me to delete. I opened the file and read it again. On page 5, next to my name in the enforcement review section, there was a handwritten note in the margin. Priority case, escalate quickly to demonstrate enforcement credibility. Priority case. I was not a repeat offender. I was not non-compliant. I was a test case. Vanessa was using me to prove to the board and the neighborhood that she could enforce the rules without mercy. She had picked me because I had challenged her once, and she wanted to make an example of me. I had the proof. I had the pattern. I had the statements. I had the receipts. But I needed to deploy it in a way that would force immediate action. I could not wait for the board to review another complaint. I could not wait for the attorney to call me back. I could not wait for the management company to correct my account. I needed to go public. I opened the neighborhood group chat and posted a new message. Emergency HOA meeting requested. Topic: Communications Director abuse of authority and fraudulent lien filing. I have documented evidence of systematic misconduct and retaliation. All residents are encouraged to attend. Date and time TBA pending board response. I posted it and waited. Within minutes, the chat exploded. Residents started asking questions. What evidence? What misconduct? What retaliation? I posted a summary. Vanessa Smith has been issuing fraudulent violations, denying legitimate appeals, charging illegal fees, and threatening liens against residents who challenge her. I have statements from 10 residents who have experienced similar treatment, plus documentation showing she planned these actions in advance. I am requesting an emergency meeting to present this evidence to the board and demand her removal. Vanessa responded in the chat within 5 minutes. This is defamatory and false. I will be consulting with the HOA attorney regarding legal action against the original poster. Any residents who participate in spreading these lies will also be subject to potential action. This chat is for community announcements only and should not be used for personal vendettas. 3 residents immediately posted in my defense. One said Vanessa had ignored her records request for 4 months. Another said Vanessa had fined him twice for the same violation. A third said Vanessa had threatened to suspend his amenities access because he had questioned a budget line item at a meeting. The chat was moving so fast I could barely keep up. Vanessa stopped responding. 20 minutes later, I got a private message from the board president. I have seen your posts in the group chat. I am willing to meet with you privately to discuss your concerns before escalating this further. Please call me at your earliest convenience. He included his phone number. I called immediately. He answered on the second ring. I introduced myself and thanked him for reaching out. He said he wanted to hear my side of the story before making any decisions. I told him I had documented evidence of Vanessa engaging in retaliatory enforcement, fraudulent violation notices, illegal fee charges, and procedural violations. I said I had statements from 10 other residents describing similar experiences. I said I had proof that she had planned the escalation against me before I had a chance to respond, and that she had sent me a threatening text message demanding I delete evidence of board misconduct. He was silent for a long moment. Then, he asked if I was willing to send him the evidence. I said yes, but I wanted a guarantee that he would review it fairly and take action if it was substantiated. He said he could not make any guarantees, but he would review everything personally and bring it to the board for discussion. I asked when the next board meeting was. He said it was scheduled for next week. I asked if I could present my evidence at the meeting. He said yes, but he wanted to review it first. I sent him everything. The timeline, the fake resolution email, the missing minutes, the forged board packet, the portal failures, the retrieval fees, the amenities lockout, the permit theft, the tow attempt, the police report, the resident statements, the payment receipt, the lien notice, the January board packet with the handwritten note, the threatening text message. I attached every file to an email and sent it with a summary cover letter. Then I called him back and confirmed he had received it. He said he had, and he would review it that evening. The next morning, I got a call from the board president. He said he had reviewed the evidence and he was deeply concerned. He said he had not been aware of the extent of Vanessa's actions, and he apologized for the board's failure to respond to my previous complaints. He said he was calling an emergency board meeting for that evening, and he wanted me to present my evidence in person. He said Vanessa would also be present and would have the opportunity to respond. I asked if the meeting would be open to other residents. He said yes. Per HOA bylaws, all board meetings were open unless an executive session was called. I posted in the neighborhood group chat, emergency board meeting tonight at 7 p.m. at the clubhouse. Topic: Communications Director Conduct Review. All residents are welcome to attend. Within an hour, 30 residents had confirmed they would be there. That evening, I arrived at the clubhouse at 6:45. The parking lot was already full. I walked inside and found the meeting room packed. Every chair was taken and people were standing along the walls. The board president was at the front table with 4 other board members. Vanessa sat in a chair to the side, her arms crossed, that laminated policy sheet on her lap. When I walked in, she glared at me. The board president called the meeting to order and explained that the purpose of the emergency session was to review allegations of misconduct against the communications director and compliance officer. He said I would present my evidence first, followed by Vanessa's response, followed by board discussion and a vote. He asked me to come to the front. I walked to the front and set my evidence binder on the table. I opened it and pulled out the timeline. I started with the October violation and explained how I had submitted proof in November that should have closed the case. I showed the fake resolution email with the mismatched headers. I explained that Greg had resigned on October 30th and someone had sent that email using his name from a different email system. I showed the missing November and December minutes and explained that the city clerk had confirmed no minutes had been submitted after October. I showed the January board packet that had been accidentally forwarded to me, including the handwritten note that labeled me a priority case. I showed the portal failure screenshots and the bounce-back emails. I showed the retrieval fee demand and the city clerk's explanation that it was not legal under Minnesota law. I showed the amenities lockout notice and the payment receipt that proved I had paid before the deadline. I showed the permit theft photos and the police report. I showed the lien notice and the duplicate payment receipt that the management company had lost. I showed the resident statements, all 10 of them. I read 3 of them out loud. One resident described being fined for a mailbox color that matched every other mailbox. Another described being charged a late fee despite paying on time. A third described requesting records 3 times and never receiving a response. I explained that every single one of these incidents had been controlled or influenced by Vanessa. Then I brought a second copy for the HOA attorney so the legal risk is obvious. I handed it to the board president and asked him to forward it to the attorney immediately. I explained that if the board did not take action, the HOA could face lawsuits from multiple residents for harassment, retaliation, and procedural violations. I said the evidence was clear, and the pattern was undeniable. Vanessa had abused her authority systematically, and she needed to be removed. The room was silent. The board president thanked me and asked Vanessa if she wanted to respond. She stood up, walked to the front, and set her laminated policy sheet on the table. She said everything I had presented was taken out of context. She said the October violation was legitimate, and I had failed to provide adequate documentation. She said the portal failures were due to system issues beyond her control. She said the retrieval fee was standard policy. She said the amenities lockout was automatic based on unpaid balances. She said the permit theft was justified enforcement of guest parking rules. She said the lien notice was a legal action approved by the board. The board president asked her about the fake resolution email. She said she had no knowledge of it and suggested it might have been a phishing scam. He asked her about the missing minutes. She said the minutes were still being finalized and would be posted soon. He asked her about the January board packet and the handwritten priority case note. She said she had no idea what he was talking about. He held up the packet and pointed to the note. She stared at it and said someone must have added that without her knowledge. One of the board members interrupted. He said he recognized the handwriting. It was Vanessa's. He had seen her writing on dozens of documents over the past year. She tried to deny it, but he insisted. He pulled out his phone and showed a photo of a previous document with her handwriting. It was identical. The board president asked Vanessa to explain the priority case note. She hesitated, then said it was just a reminder to herself to process the case quickly. He asked why she had texted me to delete the board packet. She said she had not texted me. He asked me to show the text. I pulled it up on my phone and handed it to him. He read it out loud. "You were not supposed to receive that email. Delete it immediately, or face legal action for unauthorized access to internal board communications." He asked Vanessa if that was her number. She said no. He asked if anyone else had access to her phone. She said no. He asked if she had authorized anyone to send threatening messages on her behalf. She said no. He asked her to explain how the text had been sent from a number she did not control. She had no answer. Another board member spoke up. She said she had reviewed the evidence I had submitted and she was particularly concerned about the resident statements. She said the pattern was clear. Vanessa had been selectively enforcing rules, denying legitimate appeals, and retaliating against residents who challenged her. She said the board had a fiduciary duty to protect the community, and keeping Vanessa in her position was a liability. She moved to terminate Vanessa's employment effective immediately. The board president asked for a second. Another board member seconded. He called for discussion. One board member said he was not comfortable voting without consulting the attorney. Another said the evidence was overwhelming and waiting would only make things worse. A third said the community had lost trust in Vanessa and that trust could not be rebuilt. The board president called for a vote. 4 votes in favor, 1 opposed. Vanessa was fired. The room erupted. Residents started clapping and cheering. Vanessa stood there, frozen, staring at the board. Then she picked up her laminated policy sheet, shoved it into her bag, and walked out. She did not say a word. The door slammed behind her. The board president called for order. He said the board would appoint an interim compliance officer immediately and begin the process of hiring a permanent replacement. He said all pending violations would be reviewed by an independent auditor to ensure they were legitimate. He said all fees charged by Vanessa in the past 6 months would be refunded if they were found to be improper. He said the board would work with the management company to restore trust and transparency in the enforcement process. He thanked me for bringing the evidence forward and said the board owed me an apology for not responding sooner. He said my lien notice would be canceled immediately and my account would be corrected. He said I would receive a written apology from the board and a full refund of all fees I had paid under protest. He said the HOA would also reimburse me for the cost of the police report, the certified mail, and any other expenses I had incurred while investigating the misconduct. Then he said one more thing. He said the board would be issuing a memo to all residents clarifying the enforcement rules Vanessa had weaponized, including the guest parking permit process, the document retrieval fee policy, and the records request timeline. He said the memo would also include a formal apology to all residents who had been mistreated by Vanessa, and an invitation to submit their own complaints for review. I thanked him and walked back to my seat. Residents started coming up to me, shaking my hand, thanking me for standing up to Vanessa. One woman hugged me and said she had been too afraid to challenge Vanessa on her own. Another man said he had almost moved out because of the harassment. A third resident said Vanessa had tried to fine him twice for the same violation, and he had given up fighting it. He asked if he could submit his case for review. I told him yes and gave him the board president's email. The meeting ended at 9:30. I walked out to my truck and sat in the driver's seat for a long moment. It was over. Vanessa was gone. The lien was canceled. The fees were being refunded. The rules were being clarified. I had won. Not because I had yelled louder or fought dirtier, but because I had documented everything, gathered proof, and forced the board to see the truth. The next day, I got an email from the board president. Attached was a written apology signed by all 5 board members, a refund check for $375, and a reimbursement check for $212 covering my police report, certified mail, and document printing costs. The email also included a copy of the memo that would be sent to all residents. It outlined the updated enforcement guidelines, clarified the guest parking permit process, eliminated the document retrieval fee, and confirmed that all records requests would be processed within 10 business days as required by Minnesota law. The memo also included a section titled Accountability and Transparency. It stated that the board had terminated Vanessa Smith from her role as Communications Director and Compliance Officer due to violations of HOA policies, abuse of authority, and retaliation against residents. It stated that an independent auditor had been hired to review all compliance actions taken under her authority, and residents who believed they had been improperly fined or penalized were encouraged to submit their cases for review. It stated that the board was committed to rebuilding trust and ensuring that enforcement actions were fair, consistent, and transparent. I printed the memo and posted it in the mailbox cluster. Within hours, the neighborhood group chat was flooded with messages. Residents were celebrating. Some shared their own stories of Vanessa's misconduct. Others thanked me for taking the risk to expose her. One resident posted a photo of a stack of complaints that had been sitting in her desk drawer for months. complaints she had never forwarded to the board. Vanessa says nobody complains, and a stack of complaints appears. The board president responded in the chat and asked the resident to send him the complaints immediately. 2 weeks later, the independent audit was complete. The auditor found that Vanessa had issued 63 violations in the past 6 months, of which 37 were either improperly documented, based on selective enforcement, or issued without proper authorization. The auditor recommended that all 37 violations be voided and the associated fees refunded. The board voted unanimously to accept the recommendation. Total refunds over $18,000. Vanessa tried to fight back. She hired an attorney and sent a demand letter to the board claiming wrongful termination and defamation. The board forwarded the letter to the HOA attorney, who responded with a detailed rebuttal citing the evidence I had provided, the independent audit findings, and the resident complaints. Vanessa's attorney dropped the case 2 weeks later. I heard through the neighborhood group chat that Vanessa had moved out of the community. No one knew where she went. No one asked. She was gone. And that was enough. Life in the landing at Harborview went back to normal. The new compliance officer was a retired accountant who processed violations fairly and responded to emails within 24 hours. The board posted meeting minutes on time. The portal worked. The guest parking permit process was streamlined. Residents started attending meetings again. Trust was being rebuilt, slowly but steadily. As for me, I kept my evidence binder. I kept every email, every receipt, every screenshot, every statement. I keep it on a shelf in my office, a reminder that the system only works if you hold it accountable. A reminder that rage does not win, but proof does. A reminder that when someone abuses their power, the only way to stop them is to document everything, gather your allies, and force the truth into the light. Document everything, and I will see you soon.